some prejudice, it says some prejudice to the accused, the witness should not be allowed to report them. And so Martinez interprets that decision, and on page 3 of the Martinez opinion, headings 3 and 4, third paragraph, it says that we do, however, interpret law as meaning that any doubts should be resolved in the favor of the defendant receiving a fair trial. Well, that's what we're asserting here, Your Honor, is that we're concerned that Mr. Riley's testimony may be colored by opening statements and witness testimony from the stand. We're concerned about the preservation of the truth-seeking process here. Similar to Martinez, in this case, in order to establish precedence, we assert that the facts here are hotly disputed, that Mr. Riley is a key witness and a victim in the case, who was really the only person other than the defendants who was present for many of the incidents that occurred just prior to the event and during the event itself. There were other witnesses that witnessed from afar and from a distance and at different times, but he was the only witness that was present during the encounter, all the way up through the alleged attempted murder, and then some after. Now, the state has indicated he has given prior statements, and he's given 4 prior statements, but I'd like the court to take note of the fact that there are some inconsistencies in those statements that we intend to bring out, some major inconsistencies in our opinion, and if he's allowed to sit through opening statement and other witnesses' testimony, he may, I'm not saying he will, but he may, and that's what the rule is designed to avoid, either minimize or somehow alter his testimony to minimize that potential impeachment evidence or explain it away. All of the witnesses that the state intends to call before Mr. Riley are all witnesses that are witnesses leading up to the event or witnessing the event itself. It starts with Eric Robinson and Nicole Robinson. Eric Robinson and Nicole Robinson are the across the street neighbors who called 911 in the fight. The next witness, I believe, would be Diane Townsley, who's their next door neighbor, and I believe also called 911. Mary Fitzgerald, who's the next door neighbor of Leverett and Madison, who witnessed Leverett coming and going and establishes a time frame. Kirk Madison, who has a view straight down the street of the incident and witnessed events. Scott Searles and Kendra Walls, who apparently actually met Mr. Riley and Mr. Leverett earlier in the day, and then also saw him around that time. And so and then Justin Riley. And so all of these witnesses are leading up to the event. And so essentially Mr. Riley, if he was so inclined, would have a roadmap to explain away any inconsistencies. But more importantly than the impeachment evidence, Your Honor, which is important, is the state is relying heavily on the fact of these prior inconsistent statements and the fact that we can impeach Mr. Riley if we see fit with those prior inconsistent statements. But there's an important difference in the quality of the evidence that the state is alleging would satisfy any prejudice. And that is that what Mr. Riley says on the stand is substantive evidence, okay? So what he's asked and how he answers during questioning, that's substantive evidence, that's testimony. And we're afraid that that's what's going to be altered by his presence in the court. Of course, we'll have the opportunity to impeach him, but that's a different quality of evidence than the actual substantive testimony coming from the stand. And so the rule is designed to protect the actual substantive testimony coming from the stand. And it's one thing to have Mr. Riley say something from the stand, and it's entirely different for us to say, well, yeah, but you said something different. And so our concern is that Mr. Riley will have the, by excluding Mr. Riley from the rule, he's going to have the opportunity to hear exactly everything that's being said about both the roadmap of the defense during opening statements, and then he's going to be able to conform prior inconsistencies or anything else that he might not have answered the same way based on all of the witnesses that either witnessed the event itself or the events leading up to the actual event. And so it's really the coloring of the actual substantive testimony that we're concerned with. We do have the other statements, and we intend to impeach him on some of those inconsistencies already. But our concern is that the defendants will not have a fair trial if a key witness in hotly disputed facts is allowed to avoid the rule of sequestration. So again, just to recap, we would be requesting that Mr. Riley be excluded during the opening statements and up until the time that he testifies. The state provided Booker v. State, which essentially on page 12, I believe.
I'm sorry, I didn't get that case. I got the two that you provided and the ones that I did my own research on. The Supreme Court case that I pulled was from 2000, so I don't have, well, I think you said Booker was from 2000 as well. I came up with Beasley, so I don't have Booker.
I will give you my copy. I think it's head notes 5, 6, and 7 by this particular argument, and the discussion is roughly a page or so. I apologize.
I think it starts on page 11. It's over page 12.
All right, I have that. Thank you.
And the court cites to Farina and Cerici, there's some prior decisions. Cerici, essentially all that case said was that it was not an abuse of discretion to exclude a victim or family member after giving testimony. And Farina was basically a decision that said that it was not an abuse of discretion for just the family members being present. And the indication I have is that they never testified, they were not witnesses. Now Booker says that essentially it was an abuse of discretion to exclude a victim's next of kin under this particular set of circumstances, but this is entirely distinguishable from the case here. Number one is, well, briefly, the facts are essentially that this individual was in a penalty phase. It appears he must have come back on a remand or something, but the victim's next of kin had actually established a relationship with the defendant while the defendant was on death row. They come back for a penalty phase, and the defendant was calling the next of kin as a witness, and the defendant in this case is complaining that the court excluded the next of kin, and did so for one day, but then allowed the next of kin after that day. The court did say that it was an abuse of discretion to exclude the next of kin, but under those circumstances, and if you go to head note 8 of the opinion, which is on page 12, and midway down, the sentence starts with, moreover, in this particular case, goes on to say, there is no concern that Ms. Zyromski's testimony would be tainted by her presence in court, as her testimony primarily focused on the relationship she had established with Booker after he had been incarcerated on death row. So there was no concern that her testimony would be tainted. Distinguishing that from Martinez, the court, although it did find the error harmless, it did say that it was error in a case like that where there was a possibility that the witness's testimony would be tainted, which is, of course, the entire purpose behind the rule. So we believe that Booker is distinguishable. I believe Gore, they did not establish prejudice. Martinez, it seems that the allegation that the victim's testimony, the fact that the victim's testimony could have been colored in a hotly contested issue was prejudicial, but if the court needs additional evidence before making a determination, I believe the cases seem to suggest that we may need a proffer of testimony as to, I'm not sure if you would prefer the attorneys to go into that or other witnesses if you're inclined to rule against the defense.
I think I understand the issue, and it's been set up, and the main concern for the team is the different testimony that Mr. Riley has given. Your comments also focused on Mr. Riley. What about next of kin?
Next of kin, Your Honor, I mean, technically, I believe the rule would apply to his mother. I mean, that she's been listed as a defense witness. I don't know if Mr. Will would like Mrs. Riley out of the courtroom. I don't think we really have a position as to Mrs. Riley. The testimony that Mr. Will had indicated he would be eliciting is basically the same as ours. We're not concerned with her testimony pertaining to her color. And so as far as the next of kin goes, we have no objection in that regard unless my co-counsel states otherwise. It's specifically with reference to Mr. Riley up until the time he testifies. And if the state wishes to call him first, then it would just be prohibited statements, but otherwise we would have an objection to being in the courtroom until he testifies.
Anything further from Mr. Wayne Greenlaw's counsel?
No, ma'am.
All right, what I'd like to do is to bring everyone back in. I will first swear in Mr. Riley and Ms. Riley. I assume they're both present.
Yes, ma'am.
I will invoke the rule of sequestration with the full instruction, and then I will make my ruling. So let's get everyone back in. First of all, let me express my apologies to the family members of Brian Leverett. I don't know faces yet, I only know names. I should have only excluded those related to Mr. Riley and his family members, so I do apologize. The only thing we did so far is legal argument. I need to do one procedural thing and then I'll make a ruling. My rulings apply to the Riley family, not to the Leverett family. I do apologize that I asked you to be excused for that. All right, Ms. Riley, as well as Mr. Riley, would you please approach the podium, face the clerk, raise your right hand, and be sworn in at this time.
Do each of you solemnly swear or affirm the testimony you shall give in this cause will be the truth, the whole truth, and nothing but the truth to help you God?
Okay.
Thank you.
All right, I am going to invoke a procedural rule called the rule of sequestration. What that means is from this point forward until you are done with or until this trial is over, you are not to discuss your testimony with anyone except for the attorneys involved in this case. Should you violate that rule, not only could you be stricken as a witness in this case, but you would also be subject to criminal contempt of court proceedings for not following this court's order. I want to make this real clear. You two can't talk to each other. You can't talk to anybody who is in the courtroom and who hears other testimony about what your testimony is going to be, should be, or will be. And if you violate that, you could be stricken as a witness, and as I said, subject to criminal contempt of court proceedings. If I find that this was done in the legal standard of willful I would be able to incarcerate you for up to 6 months for violating this court's instruction. So I want to make real sure you understand that and you don't have any questions about that. You also cannot have any interaction with any of the jurors in this case, whether to say good morning, the weather's nice outside, or anything else. It's easily identifiable who is a juror. They wear a big plastic badge that says juror, so stay away from them, don't have any interaction with them, don't even ride up in the elevator with them. Do you have any questions about any of those instructions? All right, you may have a seat. All right, we start off on this issue looking at the Constitution. I just want to read the Constitution just to make it clear, and that's part of the reason I wanted family members to be present for the ruling. The constitutional provision, which is Section 16B of the Florida Constitution, says victims of crime or their lawful representatives, which I'll come back and give you the legal definition of that in a minute, including the next of kin of homicide victims, are entitled to the right to be present, to be heard, and to be at all crucial stages of the criminal proceeding, to the extent that these rights do not interfere with the constitutional rights of the accused. I think that constitutional provision treats Mr. Riley differently than his family members. Legal representatives are defined as the estate of a deceased or someone who is mentally incapacitated and cannot be present themselves. So lawful representatives does not apply to Mr. Riley. Furthermore, the next of kin only applies to homicide victims. Mr. Riley is not a homicide victim. So, at least until the testimony of Mr. Riley is concluded, Mr. Riley's family members cannot be present in this courtroom. As to Mr. Riley, he has more rights than his family members do. And so then the court needs to look at the weighing standard provided by all the case law cited here today. All of the cases cited do indicate that the constitutional right of a victim is very important and to be considered by the court. However, it cannot interfere with the constitutional rights of the defendant. Defendants do have to show that there's some form of prejudice, and that has been shown in this case. And therefore, until Mr. Riley testifies, he may not be present in the courtroom. The trial court has the discretion under 90.612 to minimize the opportunity for the conscious or the subconscious tailoring of testimony. And that has been established by the defendants, and therefore, for those reasons, Mr. Riley may not be present during opening statements or until he has testified in this case. Based upon the defendant's position, which I understand and accept they don't really have an objection to Ms. Robin Riley being present, I don't find she's entitled to be present, and again, to avoid the potential taint of any testimony until Mr. Riley has testified, she and the rest of Mr. Riley's family members will be excluded until he has testified. But after he has testified, even if she has not yet testified, she will be allowed into the courtroom. Are there any questions regarding the court's ruling, Mr. Will?
Yes, ma'am. Does that apply equally to the sister who's a
It
juvenile
does.
member of public?
It does,
Okay.
because I don't see there's any constitutional provision to allow her to be present at least until he testifies. But once he testifies, all family members can be here. Okay. Anything from the defense? We'll start with Ray Greenlaw's defense. Anything from Wayne Greenlaw's defense?
No.
All right. So, I know Robin Riley and I know Justin Riley now. I don't know any of the other Riley family members, but at this time you will be excluded from the courtroom. And again, focusing on the constitutional provision, the family members of Brian Leverett qualify under the constitutional provision and are able to be here for all portions of the testimony. I'll just make a comment to them, I can't, they're not witnesses, and I can't give you any specific instruction except for your demeanor in the courtroom. However, I have instructed both Ms. Riley and Mr. Riley not to have any discussions with anybody about their testimony, except with the attorneys. That's the only people they're allowed to talk about. So if you were to talk with them about what occurred in the courtroom, I couldn't do anything to you, but I could strike them as witnesses. I just want you to be clear and understand that although you're not subject to the court's instruction, you could affect the outcome of the trial. The other issue that we discussed dealing with the reputation testimony, I believe counsel said that would not be an issue in opening.
It should not be an issue in opening, no, ma'am.
Does defense counsel agree?
I agree. Yes, Your Honor, I
Okay.
agree.
Then let's defer ruling on that until a break or later this afternoon. The jury is present, they've been present. I don't want to hold them up any longer. We'll address that legal issue at a different time.
Yes, ma'am.
Maybe we bring in the jury at this time?
Now, ma'am, we have one other thing that we need to talk to the court about, the chief will speak to.
All right?
Mr. Will and I discussed yesterday about how the case is going to proceed, and I think the court has been aware that the witnesses for the state just also happen to turn out to be the witnesses for the defense. And we discussed yesterday and agreed that a number of the witnesses that the state would call, that the defense and the state would call them as joint witnesses. And that as opposed to either not cross-examining them and or limited cross and then bringing them back, that I would be allowed and Mr. Ray Greenlaw would be allowed to question them any way that we chose and introduce evidence during the course of that, and that we would advise the jury that in fact that was the case. And at that point in time, we'll be able to conclude with the witness one time, introduce our evidence, which is already been marked, and won't have to recall any of these witnesses, which I believe should shorten this trial to 3 days. At least. The question is, obviously, it's unusual. So we have agreed to that. Mr. Ray Greenlaw has agreed to that. The question is that all right with the court?
Absolutely, 100% acceptable to the court. Anything that makes this case more efficient is acceptable. I also think it makes it more clear for the jurors. I know it's not the way the system normally runs, but to deal with one witness at one time, get it all in at one time, rather than for them to have to flip back in their notes 2 or 3 days to see what the witness said before and now what they're saying here, makes perfect sense.
Well, in discussion with a couple of the witnesses, and I can understand exactly, they want to, well, when I'm testifying, I'm going to be able to leave and not come back. And, you know, you can't tell them that, but now I think we can. So.
Well, I think we still need to say that for potential rebuttal witnesses,
Yes,
we can tell them they can go home, but they're still subject to recall. But yes, we can deal with the majority of their testimony up front.
So in my opening to the jurors, I'm going to explain that procedure unless the court wants to do it. I really would prefer you to do it, but I'll be glad to do it if you don't.
I'll address it. And let me just verify for the record that Ray Greenlaw is agreeing with this procedure as well.
Yes, Your Honor, there was discussion about it, of something I never even thought of, never seen before, but when the idea was brought up and discussed, it just seemed to make more sense so that these witnesses could be, so the jury would know that these are witnesses, are state witnesses, but they're also witnesses for Wayne Greenlaw and witnesses for Ray Greenlaw, rather than having to bring them back maybe 2 or 3 times if necessary. So we totally agree with that procedure. The other thing is, before in regards to that, when they're going to be photographs put up on the screen, I don't know if the court's aware, we're going to have to move to the other side of the screen.
Yes, because right down on top of your head.
Right.
Yes. We did what we could with the shape of the courtroom,
As long as you got a
but that was the only.
see 'em.
All right. All right. Anything further? Do Do we have all 15?
Yes.
Okay, let's go.
Just to let the court know, Ray Greenlaw is going to reserve his own.
I want to ask in front of the jury, but
Okay.
thank you for letting me know.
And I told him to go back yesterday.
Jury.
Okay, that's good point. I guess if they're gonna drop off their personal items. Yes, they do, thank you. She will.
Well, she said you were, but we didn't know which way to go, so we stayed on that.
Judge, can I address one other thing?
You can, and everyone may be seated, she may be back there 5 minutes, she's just getting them, you know, where their personal items go, breaks, et cetera. She's getting them done.
During the course of this case, as you're well aware, there was 2 different dates where we had a stained ground hearing, and there was a lot of testimony used from that. And I believe that Mr. Will, and so on, I believe Mr. Ballerino will as well, at some point in time, will talk about testimony that was introduced at that hearing, whether it was or whatever the case may be. And I think maybe Mr. Will may have some other threat. But we've agreed, obviously, not to refer to it as what it's called, stained ground hearing, because of the potential prejudice that the juror might think of hearing. So we've agreed that we will just simply refer to it as a prior statement, so that there won't be any impressions going from that.
All right, thank you for that heads up. We're ready?
Jury.
Once everyone's in their place, we'll just have everyone remain standing. At this time, ladies and gentlemen, please raise your right hand and be sworn in as jurors in this cause.
Do each of you solemnly swear or affirm that you will well and truly try the issues between the state of Florida and Ray Curtis Greenlaw, and Wayne Robert Greenlaw, whom you shall have in charge, and a true verdict rendered according to the law and the evidence, so help you God? Panel sworn, ma'am.
Thank you. You may be seated. Everyone else may be seated. Good morning, ladies and gentlemen. I know that I spoke with some of you yesterday, but I haven't seen some of you since Tuesday. I apologize to those who were here yesterday, but I want to repeat some of the things that I said since I didn't have an opportunity to talk with those that we excused on Tuesday until we can make our determination for who our jury was going to be. First of all, I want to advise you that we are going to keep a schedule for this trial from 8:45 in the morning until 6 p.m. in the evening. That always modifies depending on if a witness finishes at 5:40. We're not going to go till 6 o'clock. There's no reason to start another witness. But that's the general schedule I want you to be prepared for. That's a little longer of a day than we normally do. We are a little behind. It took us longer to get a jury in this case than we anticipated. So we are going to try to make up that lost day by going an extra hour every day. I'm doing that to hopefully keep it to the schedule where we can be completed by next Friday. And so I'll keep you updated as we go along as to where we are on that schedule. But I wanted to let you know that that is what we will expect. We did not have to come in until 9 o'clock this morning, and we didn't quite even make that. There were some legal matters that had to be addressed before we could start the trial. And so I have ruled on all of those matters with counsel this morning, and we're ready to start the trial at this time. A couple further other comments for those of you that weren't here yesterday. When you come, and it looks like most of you did, anyway, this courtroom gets really hot and it gets really cold, and they can't moderate the temperature. My suggestion is you bring a jacket. You can take it off when it's warm, you can put it on when it's cold. That makes it more comfortable for you, so you're not thinking about the comfort instead of listening to the witnesses. You may have seen some of the jurors that were here yesterday walk in with a cup of coffee. That is acceptable, a bottle of water, a soda, whatever you want at any rate you can pick up, as long as there's a cap or a lid on it. The reason for that is the county commissioners for Volusia County own, well, actually the citizens of Volusia County own this courthouse. But the county commissioners tell us how we can and cannot use this courthouse. They don't want food or drink in the courtroom, because if you spill it, it stains the carpet, then the carpet has to be replaced. That comes out of your tax dollars. So they say no food or drink. I bend that rule. I bend it because I don't think it's fair to a juror to require them to sit there all day long and not have maybe a little pick-me-up of a shot of caffeine from their Coke or coffee. So I allow you to do that as long as you keep the cap on when you're not drinking for that purpose. You need to wear, and all of you did, but you need to wear your juror badges at all times. You will hear me throughout. Remind witnesses, instruct witnesses to stay away from you. They need to see the juror badge so they know who to stay away from. The attorneys are also advised not to have any communication or contact with you. And they will get to know your faces over the next several days, but the juror badge helps, especially at the beginning. There will be days when you come into this courthouse where the line downstairs at the metal detector is really long. The deputies working the metal detector downstairs will look for juror badges and pull you to the front of the line. They know you need to get up here so we can get to work on the trial. So please wear the juror badges, although they're not the greatest fashion statement. I understand that. I believe we have all of your contact numbers. Those of you that left on Tuesday, we got contact numbers from them to call you back. Obviously they worked, you came back. And we got those from the people that we released yesterday to come back today. If there's any need to change any of those numbers you've previously given, please let Deputy Murchison know. As I told you before, she keeps the phone numbers under lock and key. We only use them in the event that something happens to the courthouse, electricity goes out, we can't have a trial, we'll call you and tell you not to come in. And they will be destroyed at the end of the trial. All right, ladies and gentlemen, as you know, you have been selected and sworn to serve as the jury in the cases of State of Florida versus Wayne Greenlaw and State of Florida versus Ray Curtis Greenlaw. This is a criminal case. Wayne Greenlaw has been charged with first-degree murder and shooting into a building Mr. Ray Curtis Greenlaw has been charged with first-degree murder, attempted first-degree murder, and shooting into a building. The definition and the elements of those specific crimes will be explained to you later. It is your solemn responsibility to determine if the state has proved its accusation against these defendants beyond and to the exclusion of a reasonable doubt. Your verdict must be based solely on the evidence or the lack of evidence and the law. The indictments that were issued against these two defendants is not evidence, and it is not to be considered by you as any proof of guilt. It is my responsibility to decide which laws apply to this case and then to explain those laws to you. It is your responsibility to decide what the facts of the case may be and then to apply the law to those facts. Thus, the province of the jury and the province of the court are well delineated and they do not overlap. That's one of the fundamental principles of our system of justice. Before proceeding further, it may be helpful for you to understand how a trial is conducted. First of all, scheduling-wise, we will take a mid-morning break, a lunch break, a mid-afternoon break, and then the recess for the evening. So you will be in those chairs for an hour and a half to 2 hours at any one given stretch, but we will take breaks in between. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what they believe the evidence is that will be presented during this trial. But what they say is not evidence, and you are not to consider it as such. After the opening statements, the attorneys will be calling witnesses to testify under oath. They will be examined and cross-examined by the attorneys. Also, documents and other exhibits may also be produced as evidence. I want to tell you that the normal way that a trial works is that the state presents all of its witnesses first, and then after they're done, the defendants, one by one, would be able to call all of their witnesses. In order to be a little bit more efficient and to make this go smoothly, the attorneys have requested, the defendants have agreed, and this court has agreed to allow witnesses that would be witnesses for the state and also witnesses for the defendants to all be dealt with at one time. Instead of being called by the state, go home, a couple days later, come back and testify for the defense. All the information is going to come in. When Mr. X sits on the stand, everything about Mr. X is going to come in at one time. That's slightly different than the way a normal court works, but we are doing that because we think that will save time, and it also saves the inconvenience on that witness from having to come back a couple of times. So although you hear me talk about state's case, defense case, at certain times and with certain witnesses, it's going to be a joint witness. After the evidence has been presented, I will instruct you on the substantive instructions that you would need to evaluate this case. After I give you the legal definitions of the substantive instructions, the attorneys will then make their closing arguments to you. After they make their closing arguments, I would then read instructions to you on how to procedurally go through your deliberations to the point where you return a verdict. To help you anticipate some of the instructions that you're going to hear, I want to read to you two instructions at this point. They deal with the issue of reasonable doubt and the burden of proof, as well as what you can do in weighing the evidence. You don't need to remember any of this now. I just want to put it out there for you to think about so that when the trial starts, you have this in your mind. You will hear this again at the end of the case. Plea of not guilty, reasonable doubt, and burden of proof. The defendants in these cases have entered a plea of not guilty. This means you must presume or believe the defendants are innocent. The presumption stays with each defendant as to each material allegation in the indictment through each stage of the trial unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which these defendants are charged was committed and that these defendants are the persons who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt does not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of a defendant may arise from the evidence, conflict in the evidence, or lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. Weighing evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with other testimony and other evidence in the case? After all instructions are given to you, you would then retire to consider your verdict. You should not form any definite or fixed opinion on the merits of this case until you have heard all of the evidence, the arguments of the attorneys, and the instructions on the law. Until that time, you may not discuss the case amongst yourselves. During the course of the trial, we will be taking recesses, during which you are permitted to separate and go about your personal affairs. I'm sure you've heard of cases before where a jury is sequestered, which means they don't get to go home. They have to stay in a hotel until the trial is concluded. That's not this case. You will go home at the end of the evening with the understanding that you will follow the court's instructions on not discussing the case with anyone and not attempting to research about anything about the case. If anyone does attempt to say anything to you in your presence about this case, please tell them to stop, turn around, walk away from them, and immediately report the matter to Deputy Murchison. They'll let me know, and then we'll address the matter as soon as possible. And as we have discussed, if you notice the witnesses and attorneys avoiding you during our breaks, please don't think they're being rude. As we indicated, they are avoiding the appearance of impropriety or having any improper discussion with you. And please assist us in that regard by not engaging in any conversation with any of the attorneys or any of the witnesses. The case must be tried by you only on the evidence presented during the trial, in your presence and in the presence of the defendant, the attorneys, and myself. Jurors must not conduct any investigation of their own. This includes reading newspapers, watching television, or using a computer, cell phone, internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in the case. This applies whether you're in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during this trial. Jurors must not have discussions of any sort with friends or family members about this case or the people and places involved. So don't let even the closest family member make comments to you or ask questions about the trial. And in this age of electronic communication, I need to stress again that just as you must not talk about this case with anyone face to face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate about the case. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of a defendant to prove his innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt, and the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections that they feel are proper. When an objection is made, you should not speculate on the reason why it was made. And likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, or what a witness might have said had they been permitted to answer. And let me pause here for just a second. I have no way of knowing exactly what's going to happen during this trial, but I have enough experience with trials to know that there will be portions of most trials that I call the jack-in-the-box portion of the trial. What I mean by that is when we get to a certain witness, certain portion of the trial, there may be a lot of objections. You've heard me before say, you decide facts, I decide law. I don't get to be in the jury room with you when you decide the facts. You can't be in the courtroom when I decide law. So when an objection is made, that's a legal decision. Sometimes I can make the decision without any discussion. But if there's any discussion that's needed, or if any of the attorneys ask permission to have discussion on that objection, I'll have to have you removed from the courtroom. You go back to the jury room, sit down until I make the decision. Then you come back out. There are times where you'll go out, you'll come back, you'll sit down for one or two questions, you'll get up, you'll go back to the jury room, you'll come back in, you'll sit down for one or two questions. So anticipate that. It's normal. It's part of the trial. It doesn't happen in every trial, but if it happens, try not to let it affect you in any manner whatsoever. You can get frustrated, but just don't take it out on any of us here in the courtroom. It is normal. All right, let's talk about notes. Deputy Murchison has our standard issued notepads for each of you, as well as a pencil. She'll be passing those out at this time. If you want to take notes during the trial, you may do so. On the other hand, you are not required to do so. It'll be left up to you individually. Any notes that you do take will be solely for your personal use. However, you may not take them with you when you leave the courtroom. That's the reason we give you the same notepad, so we can make sure that everybody is writing on the same, and she can look for that notepad when you leave the courtroom. Whenever you leave the courtroom, you leave your notepad in your chair upside down so nobody can read your notes, or lack of notes. It doesn't matter, but nobody's going to see that. At the end of every night, she collects them. She puts the notes under lock and key until the next day, and then provides them, your same pad, back to you at the beginning of trial each day. After, you will be able to take your notes into the deliberation room, but after your deliberations are completed, Deputy Murchison collects the notepads and shreds all of your notes. So nobody's going to see your notes except for you. And if you want to share them with another juror when you're back in the deliberation room, that's up to you. But none of us are going to see your notes, and so you can take them, you don't have to take them, and we won't know if you did or didn't. If you do take notes, don't get so involved in taking notes that you become distracted from what's actually occurring here in the courtroom and at the witness stand. Your notes should only be used as an aid to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of another juror. Notes are not entitled to any greater weight than each juror's memory of the specific evidence. All right. Mr. Will, for the state, are you ready with your opening statement?
Hang on.
You may proceed.
May it please the court, gentlemen, ladies and gentlemen of the jury. During the early morning hours of October 29th, 2011, Ray Greenlaw and Wade Greenlaw stood side by side in the darkness and fired 26 rounds into the carport of their neighbor's house. They were angry, they had been drinking, and they killed Brian Leverett in cold blood. There was no reason for this killing. It was done without significant provocation. And after they emptied their semi-automatic weapons, they walked calmly back down the street, sat on their own front porch, and lit a cigarette. Good morning. My name is Ryan Will, and over the course of the next week, I'm going to present to you a very clear case of first-degree murder, attempted first-degree murder, and shooting into a building. But before I do, I want to